You can give me a thumbs up or,
Thumbs up.
all right, thank you. I appreciate everyone coming today and spending part of your Saturday engaged with the League of Women Voters, Kansas City, Jackson, Clay, and Platt. So I want to get the meeting started and welcome everybody to our September member meeting. And I wanted to just let you know if you're a longtime member or whether you're joining us for the first time, we appreciate you being here and being part of our community to help to protect democracy and empower voters. The work we do now is more important than ever. And across Missouri and across the country, we are witnessing challenges to things like fair representation, access to the ballot, and just general public trust in the institutions of government. But as members of the league, we're not passive observers. We are informed advocates, educators, and citizens. So it is an important time to be those things. Um, and I just want to reiterate some of the activities that we continue to do in our community, which is registering voters and voter education, candidate forums, legislative advocacy, and we're working to address um, DEI within our organization. Um, so I just want to highlight that our mission isn't just about elections or a certain finite period in time. It's about making democracy work every day for every people and just giving access to voice and vote within our community. So with that, I want to touch on just a few things. This has been actually a fairly busy week, unexpectedly busy in this state of Missouri and in our Missouri legislation houses. Um, so I wanted to acknowledge the things that are happening right now and currently, which we know that there has been a redistricting debate across our country, talking about congressional maps and representation. And I want to acknowledge the fact that on Friday, that the Senate and House have both moved a map on to be examined and by the governor. And this congressional map, obviously, it affects our league membership area significantly in that it splits the current uh, House District 5, which is Emmanuel Cleaver's represented district, into basically three districts. It spreads it out kind of laterally across the state of Missouri. Um, and uh, we anticipate that Governor Kehoe will sign the legislation. And if anyone has updated information that I'm not reflecting what is active and current, please just raise your hand or speak. Um, but I wanted to just acknowledge that also in that legislation that moved through in special session, um, that part of it is uh, really preparing a referendum on the initiative petition process as well. So, and I don't know if anyone has been following the legislation more closely than me and would like to just speak for a second on what the effects on the initiative petition process are. Okay, well, um,
Oh,
yeah.
this is Kelly here. My understanding is that they're wanting to change it so that instead of a simple majority across the entire state to pass an initiative petition, it would require each district to pass it at a majority. And so one district with 49% and the others at 99%, it wouldn't pass, is my understanding.
Which, as the League of Women Voters, we feel like the initiative petition process is an important way for people, for citizens to participate in democracy. And so we would oppose any legislation that ends up interrupting or changing the petition process in a way that makes it harder for citizens to be able to be voiced and represented. So I did want to make sure we highlighted that. Um, I want to mention one other thing. So the Attorney General has moved on to a federal position, and in August, Governor Kehoe appointed Catherine Hanaway as Missouri's 45th Attorney General. I want to mention this notably because she is the first woman to serve as Attorney General in the state of Missouri, and she was sworn in this week. Yes, Laura.
Yes, I just wanted to say that the attack on the IP process is a great time for us to educate voters about the fact that we have this process and we're one of only 26 states who do, and to direct anyone you know to our public page where they can view the graphic booklet that Greg Woodham's led our voter education committee to create. And anyone can view that. Missouri has a superpower booklet on our website.
Great. Thank you for the reminder and the pointing to directions on our, or to resources on our website, which there are many. And if you haven't had a chance to go on our website and just look at some of the resources that are available, I encourage everybody to get on and do that. Um, and also, please, as a reminder, please read the newsletters that come out. I know this meeting was announced on the newsletter, so that maybe that's how and why you joined this morning. But also, there is an event later this week that the reminder and the flyer in the newsletter. And the newsletter uh, can also be a source of finding out how to connect with committees that you may want to serve on that you may be interested in. So that is also a great place to learn about those opportunities as well as the website. Um, just, as an overarching theme, with the league really interested in voter representation and fairness. I know that I submitted public comment. Uh, it's been a week and a half ago to submit on this particular legislation that went through on special session. But public comment is a way that you can get involved and help to um, just add a voice to help guide our legislators toward a equitable and fair end, or an end that represents your interests. Um, so, I don't actually think I need as much time as allotted to me this morning. Um, but I did just want to welcome you and tell you that no matter what your skills and strengths and interests are, I believe that we can find a place for you to engage within the League of Women Voters Kansas City, that will be able to utilize your strengths or interests to help further supporting our democracy. And so I just wanted to move on, and we'll go to the next portion of our program this morning, which is we are going to have a brief video that is Not in Their Wildest Dreams, Peace, Love, and Vote trivia prep. And I am going to pass this on to, I'm not sure, is this Joyce or Anne that would like to present this?
I think I'm doing it,
Oh,
Joyce.
perfect. Perfect.
Okay, and I did want to mention that after the first showing of the Not in Their Wildest Dreams, we're going to have Diane Golden speak about the Jackson County vote coming up September 30th. Is that correct?
Yes, I believe Diane's speaking on that and also just the current goings on in the Jackson
Okay.
County legislature. Yeah.
Okay. I just because that wasn't in the plan that we sent out originally, so I wanted people to know that she was coming up. Okay,
Yeah.
so let me share my screen.
And Joyce, we may not be able to see your screen yet.
Okay. Can you guys see the video now?
Nope, not yet, Joyce.
How about now?
Yes. Awesome.
Yay.
Joyce, I may not have sound yet.
Joyce, you might want to unshare and make sure you check share sound before you click the share again, because I'm not getting sound either. I doubt if anyone is.
Joyce? Joyce, the video is
Yeah.
not the video is not giving us any sound.
I'm sorry, I can't hear you.
Oh, okay. The video is not giving us any sound. So you may need to unshare and then share again and just click share sound.
Oh my goodness. Okay.
So when you share, you can click the side
Yep.
button that says
Yeah.
share sound. Okay.
Now I've got to get back to the right. Can you hear it?
Awesome. Yes. Thank you.
Welcome, everyone, legislators, judges. Since 1820, when Missouri first became a state, we've had a total of 122 judges to ever serve on this court. To date, only 7 have been women.
In the fall of 2023, Missouri shattered a centuries-old precedent, becoming the 14th state in the U.S. to have a majority female Supreme Court. Now, for the first time in its history, Missouri's Supreme Court is shaped by a majority of women, trailblazers who have defied the odds and rewritten the narrative. Each of these 7 judges brings a distinct voice, a unique perspective, and an unwavering commitment to justice. They are not the same, they do not always agree, but what unites them is their dedication to the law and to the people of Missouri.
Before there was a path, these women built one. Before there was precedent, they set it. They are the trailblazers of the Supreme Court of Missouri, pioneering jurists whose presence and leadership forever changed the legal landscape of the state. The first was Judge Ann Covington. In 1989, she made history as the first woman appointed to Missouri's highest court. But her groundbreaking journey actually began 2 years prior, when she became the first female judge on the Missouri Court of Appeals. Known for her quiet strength and determined leadership, Judge Covington proved not only that a woman could serve on the bench, but that she could do it with unmatched excellence. In 1993, she became Missouri's first female Chief Justice, serving for over a decade with distinction. She retired in 2001, leaving behind a powerful legacy and a path for others to follow. Judge Laura Denver Stith followed. A native of Clayton, Missouri, and former judge on the Western District Court of Appeals, she brought a rare blend of intellect, empathy, and consensus building. As Chief Justice from 2007 to 2009, she sought unity amid divergent opinions, always working to bring colleagues together. She retired in 2021 after 26 years of judicial service, more than 2 decades of that on the state's highest court. Judge Mary Russell joined the court in 2004. Hailing from rural Missouri, she brought with her a deep understanding of the state's communities, along with years of experience on the Missouri Court of Appeals Eastern District. In 2014, she became Missouri's 3rd female Chief Justice. Judge Russell is widely respected for her thoughtful deliberation, institutional knowledge, and unwavering commitment to access to justice. Her steady leadership continues to guide the court today. Judge Patricia Breckenridge joined the court in 2007. Her judicial career spans over 4 decades, beginning in 1992 as the first female associate circuit judge in her rural county. By 1990, she was serving on an all-male bench at the Court of Appeals, breaking barriers once again. She led as Missouri's Chief Justice from 2015 to 2017, and she retired in 2023. Known for her precision and attention to detail, Judge Breckenridge helped elevate the quality of legal writing and strengthen courtroom procedure throughout the state. In 2021, Judge Robin Ransom was appointed to the court. She became Missouri's first African-American woman to sit on the state's high court, a landmark moment in the state's history. Her entire legal career has been devoted to public service, from public defender to family court attorney to circuit and appellate judge. Colleagues describe her as humble, humorous, and deeply committed to justice. Judge Kelly Broniak arrived in 2023. A prosecutor turned appellate judge with small-town Missouri roots, she was serving as chief judge as the Eastern District Court of Appeals at the time of her appointment. Her arrival, just before Judge Breckenridge's retirement, gave the court its first ever female majority. With a love for women's basketball, she brings the same values of diligence, teamwork, and determination to the bench. Just 2 months later, Judge Ginger Gooch was appointed. A seasoned litigator and former Southern District Appellate Judge, she began her legal career as a clerk for Judge Ann Covington. Today, she continues her mentor's legacy. Though soft-spoken, Judge Gooch brings clarity, insight, and deep value to the court's deliberations. These women have shaped Missouri's Supreme Court, and through it, the very rule of law in the state of Missouri. Their stories are not just milestones in history, they are blueprints for progress, examples of service, and powerful reminders of what's possible for the women and jurists who will come next.
This Supreme Court building was built with money left over from the 1904 World's Fair. It was not very accommodating for females. For example, in the conference room, there was an adjacent room that it was clear that was not open to me.
Then this was my first job in Jefferson City as a law clerk here at the Supreme Court. And I was dressed in the traditional uniform that people say, oh, I bet you were counting on coming back here and being a judge someday. And I'm like, are you kidding? It wasn't even dreamable for a girl to be a judge on the Supreme Court. I grew up in a time when if you wanted a job, you looked for the classified ads in the local newspaper. And the headings were help wanted male, help wanted female. And you didn't apply for a job outside your gender.
People would come up to me and go, you're a judge? You don't look like a judge. And I'd say, actually, I do. Now they don't say that because there's enough women judges that it's normalized, and that's a wonderful thing.
I spoke to my grandson's third grade class recently, and I put up a picture of all of us on the bench. I said, what do you guys notice kind of unusual about this picture? And one student goes, you're all wearing black robes? No, there's like more women in the picture than men. Well, I'm optimistic that the younger generation doesn't have to experience the barriers that we did.
When I was applying for the Southern District, multiple people told me, you'll need to figure something else out, Ginger. There's no way the governor will appoint 2 women back to back. And the governor did. And in fact, he appointed 3 women back to back.
And the judiciary has led society in recognizing the value of having diversity. It isn't just the physical characteristics, but it's life experiences, it's work experiences. I have no doubt in my mind that I am a judge because of my 9th grade civics teacher who taught us about those 3 branches of government, and she taught us about the judicial system equally to the others.
My mom and dad were very civically minded and very involved in the community in St. Louis. Part of growing up was knowing that your main job in life was making a difference in the community. As I grew up, it was during the Watergate era. What I saw good at that time was the lawyers who defended our system. I and all my siblings were inspired by that to become lawyers. Law was very much part of who we were, and justice, growing up and caring about justice, that's how I wanted to get involved and make a difference.
So when I was first practicing law, there was a particular courthouse in Pike County, Missouri, where as a woman lawyer, if you were going to be appearing in that court, you had to have a skirt or a dress on. And if you didn't, you were sent home. When my law partner initially hired me in 1984, clients would ask me, are you tough enough? You know, can you stand up to that other attorney down the street who's really gruff and mean? And then you'd have clients that would come in and say, oh, I hired you because you were a woman, so I thought I looked good in front of the judge that I had a female attorney. So it was kind of funny how people viewed us not so much on our ability, but by our gender.
This is the picture of my first trip to Jefferson City. And just by pure luck, the governor, Kit Bond, was signing a new bill into law that lowered the majority age to 18 from 21.
And I wish I would have dreamed big. Dad was a farmer. We had a very traditional upbringing. And although I was valedictorian of my high school class, graduated summa cum laude from college, I lacked a lot of confidence. I knew when I went to law school, I would only be going to get the knowledge to maybe work in a corporation someday. Did not ever, 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 ever wanted to work in a courtroom. And look where I am today.
You know, when I went to college, I was telling my dad, you know, I think I'm going to do something in computers. And he's like, oh, no, that's a fad. God bless his soul because he fads. But every time I think of that, I'm like, oh my God, I could kill him. First job I got was in the public defender's office representing juveniles. And that's where I think the first little flicker of interest really happened. We're not talking about the civil cases and high dollar things. These are kids who are in really dire straits and they need a voice.
When people would ask me what I wanted to do, I would kind of whisper, I want to be a judge, but I didn't know any women judges, so it just seemed something that was impossible. And I realized with Judge Covington that it was possible.
One of my professors at William Woods College in Fulton encouraged me to go to law school. You know, I don't know that I would have considered law school had she not suggested it.
Thank you for coming today to join me in this special occasion. I thank Governor Parson for the opportunity to serve, and I pledge I will continue to work hard and do my very best to serve Missouri's citizens. I'm grateful for Judge Covington taking a chance on me all those years ago and allowing me to clerk for her as my first job after law school. Thank you for your example of quiet confidence and professionalism. I will spend the rest of my career trying to live up to your example.
Thank you, Judge Gooch. And would you now join your colleagues on the bench?
I clerk for Judge Covington, and she has been an inspiration to me. I'm so grateful that I was able to witness firsthand her professionalism and hard work.
Judge Gooch is more and better, both as a judge and a human being, than I could ever have hoped to have been. That is absolutely true.
Before 1940, if you wanted to be a judge on the Supreme Court of Missouri, you ran as a Republican or a Democrat, and you went out and campaigned, and you raised money, and you maybe made some promises on how you were going to vote. People felt like, our judges were beholden to political leaders, were beholden to big money and contributions, and were not maybe necessarily always following the law. The initiative petition that was proposed and adopted in 1940 was a whole new way of selecting judges. It was called the Nonpartisan Court Plan. It's been such a success in Missouri that many other states have copied it. Even some newer nations have adopted a form of this nonpartisan court plan.
When there is a vacancy on the Supreme Court, any attorney who is in good standing and of the age the Constitution requires can apply for that job.
The commissioners meet with the applicants, and then they conduct a public interview.
The name that the governor picks, that person then becomes the judge. They're no longer allowed to have any political activity, if they ever had any in the past, cannot have yard signs, they cannot make contributions, they can't go to fundraisers. Then that particular judge then serves for a full year, and at the end of that full year, the next time there is a general election, that name is on the ballot, and it'll say, should Judge Jones be retained in office, yes or no? There's a job performance review done on each judge that's made public. Anybody can Google a judge and read their opinions, find out any information that they need to help them in making their decision as a voter and whether to vote yes to retain the judge or not.
My name is Mary Russell, and right now it's my turn to be the Chief Justice, and we're glad you came over here today to learn more about how the Supreme Court works.
There are two ways a case arrives at the Supreme Court. One is the Constitution provides that review of a trial court's decision comes directly to the Supreme Court, and the other is every decision of the court that is in a contested case. The losing party is entitled to an appeal, to a review to see if there's a material error. Probably 95% of the cases go directly to the Court of Appeals. And then the Supreme Court, under the Constitution, can review the decisions of the Court of Appeals when it's a matter of statewide importance or interest.
I'm here not to agree with someone, not to go with the majority, but to stand up for what I think is right under the law, whether it's popular or unpopular. That doesn't mean being obstreperous. That doesn't mean standing by some position I have. If somebody else has a better idea, I very much say thank you.
We just try to make sure that people know we're accessible. We're not going to tell you about cases and decisions, but we are accessible to just talk about how things work. And the more you know about the process, then the better the process is. You can only improve it if you participate. And a lot of people won't participate unless they know that they're being encouraged to and that we really want that. So that part of the job is a lot of fun.
All right, you may be seated. As a judge, get rid of all your biases, get rid of all your prejudice, and you're going to decide this case based upon the words in the law, the statute that you have to interpret. You can't add punctuation, you can't subtract punctuation, you can't add in words. And I play a little game with my audience called You Be the Judge. Maybe a grade school student on the case of the missing recess. And they see that they're citizens too, because these are things that are happening in their lives right now.
We really like to get out into the communities and into the schools and kind of help enlighten citizens on how our branch of government actually operates. Sometimes what they see on TV may or may not be accurate.
Civic education is so important. Persons who understand the role of three branches of government keep the United States of America, keep the state of Missouri in order.
All rise. Hear ye, hear ye, hear ye. Honorable Supreme Court of the State of Missouri, and Bank and State. Chief Justice Mary Russell.
Please be seated. I had the chance to go to hear arguments at the Supreme Court. It's just great to, I think, see these thoughtful judges on the bench who are really doing incredible things to shape the law in the state and doing it with a lot of heart and intention.
Many times judges are called upon to decide cases in a way that they absolutely would not do. So it makes it tough.
We don't even see most of the people who are the litigants. We see their lawyers. And so I always remember someone is depending on this decision one way or the other. And it just helps me to stay invested emotionally and legally to do the right thing.
That's really important as a judge, especially a trial judge. We may see a lot of different cases. Some of them involve big companies and lots of money. Some involve individuals and very little money. But each case is the most important case in the world to that party.
So I hope my legacy is deciding cases according to the facts and the law, fairly and impartially, and that I had a great passion for the improvement of the system of justice.
I would like to be remembered as helping other people, because at that time, there were almost no women involved in committees of the Supreme Court. I feel grateful that I was able to do that in some ways when I came to the court.
I think the earlier you have that social initiation into the profession, the more you tend to understand the weight of the oath that you've taken to be an attorney. And I think the best advice I've ever been given is to always just be yourself.
Don't impose limitations on you. Don't let someone else impose limitations on you. You have to believe in yourself.
And I always say in speeches that these are the 6 siblings I never asked for. When we get together, it's fun. You can be different, but in the end, we all have a common purpose, and we really work hard to make sure that that happens.
There are enough women in the practice, there are enough women on the bench, there are enough women leaders throughout our society that we finally shifted. And so the women who apply and the men who apply are being judged on merit, and that is exactly how it should be.
So that's going to be one of our main questions that we're going to be looking at throughout this is what is the basis upon which government is treating people differently and why?
When I started, the majority of our incoming class was male. Women were a much smaller group. Now they're a slight majority. That's really exciting because that's a pipeline thing. That means that those are now women that are going to go be lawyers and judges and all sorts of things. What that all really means is we have a long game. The class of 20 years ago is now the class that's sitting on the bench today.
Some days I wake up and I'm like, Lord, I didn't ask to be the decision maker for all these people. I've got my own problems to deal with. And you've got to be up to the challenge for that. Every day is not going to be a good day. And I remind myself every day of what a privilege it is.
Advice I give to young people today, take advantage of opportunities, be curious, be honest, guard your reputation, find a good mentor, and be appreciative of their help.
Get involved in your community, get involved in your profession, whatever it is. Everybody out there can do big things.
Don't tell yourself no before somebody else does. This is not a job I ever saw myself being in, but other people saw something in me that maybe I didn't see.
Try to be kind, always, remembering that it's people who are involved in everything that we do and everything that we touch.
What I want people to be able to do is to be able to find the thing that they like and that they're good at. For most of them, that means also making a difference in some way in the world.
Please join me in welcoming Chief Justice Russell.
Thank you, President-elect Dyer. And good afternoon to all of you. I'm honored to be here celebrating the 80th anniversary of the Missouri Bar. And let me tell you, from up here, you all look pretty good for 80.
I have every expectation that the judiciary will continue to lead, make things more just and more fair, not just who serves in it, but how people feel when they come into the courtroom. It gives me a sense of pride to think, just as a member of the judiciary, we are changing society.
Coming back to the buildings, I feel that I'm coming home still. I am extraordinarily grateful for the blessing, the privilege of having been able to do what I have done professionally.
Seeing a majority female Supreme Court in my own state means the world to me, and it means the world to all the girls that I study with at Mizzou Law. I can take comfort in the fact that these women have done it and they've led the way for me, and I know that even up to the highest office that there's a spot for me.
My middle daughter, when I got appointed to the Court of Appeals, was 5 or 6 years old, and she said, "Mom, you're a lawyer, right?" And I said, "Right." "And you're a judge, right?" And I said, "Right." And she paused for a minute and she said, "Can only girl lawyers be judges, or can boy lawyers be judges too?" And I thought, what a wonderful world that this is the question my daughter would ask. She didn't see any limitations for her. She was worried about her dad or her friend's brother.
I believe that none of us wants to be thought of as anything other than there's a good lawyer, not there's a good woman lawyer. And having the adjective woman placed in front of it is not something we like, have ever sought, or really want to project.
My happiest moment as a judge was, as my mother was older, they were reflecting back on their life. She said, "You know, I'm so proud of Laura." And she didn't say because she's on the court or because she's a lawyer. She said, because she's made a difference in her life.
I'm looking forward to seeing those pictures on the 3rd floor be sprinkled with female faces.
My path in the judiciary was certainly not straight, and many times I was told no before I was told yes.
I know that one of my colleagues referred to me as the girl, not only behind my back, but also to my face.
I like to tease when I go out and speak, and I tell people we can make the vote. I'm thinking we might consider changing the black robes to pink.
Welcome to the first one ever with a female majority Supreme Court.
Back to you, Janelle.
Thank you. Thank you, Joyce, for the video. I appreciate it. Yeah. So now I would like to introduce, let's see, and just make sure that yes, Diane Golden, who is on the call right now too. She works with the, oh, let me turn on my video. She works with Observer Corps, and Observer Corps has been observing the Missouri legislature for some time. And we all know from the news that we have heard some significant challenges that the Missouri Jackson County legislature has been dealing with in the last 2 years or so. And so I will just pass the baton over now to Diane, and she will give us an update on the Missouri legislature. Thank you, Diane.
Problem. Well, let me see, make sure I'm unmuted, right? I had two unmute
Yes.
signals.
Yes.
I don't have anything big prepared, and I tried to close my shade to get less light in here. Sorry, I don't know. Yeah, sometimes my camera just likes more light. I don't have anything prepared. I'm kind of filling in for Joe or Terry, somebody else. But before I even start, I will say I enjoyed the video. I serve on the Judicial Review Performance Committee for the Nonpartisan Plan. And just FYI, the Supreme Court is suggesting some new rules for when you go vote for retention, there's a group that puts out evaluations. That's the committee I serve on. And the Supreme Court is suggesting changes in the way that performance is done. So we're actually meeting right now to consider what they're suggesting and see if that makes sense in terms of the evaluation we do. It's an interesting process. Judge Breckenridge that was on the video serves. There's some retired judges on it anyway. It's an intriguing process, and I'm on there as a non-attorney, which makes it even more interesting. But I'm hopeful that we don't end up with a change that is not helpful in the end. So anyway, just FYI. Jackson County Legislature. I've been observing them now for probably 7-8 months, something like that. And unless you've really not heard any news for the last half year or so, you're well aware that there have been significant issues with their function. They could not pass a budget for months and months and months, or actually the legislature passed a budget. The county exec vetoed it. They couldn't override the veto, so there was this stalemate for months on end, and new funds at least could not go out. They had to live under the old budget. The league, Kansas City League, set up a task force that Joe Holt and I are sort of co-chairing to review the situation and see if there was anything that could be done other than just bemoaning the fact that there was such dysfunction going on. The longer I observed, the more apparent it became to me that clearly there are some personal conflicts between, in particular, a few of the legislators and the county executive. There is just a fundamental personality conflict there that I don't think will ever resolve without the people changing. But far beyond that, there are fundamental structural problems with the county charter and the legislature. And the more this task force subcommittee looked at it, it became just really clear that a lot of the problems are the fact that the charter has not been updated, has not been kept current, and as problems have been identified, the charter wasn't changed to address those problems, which has put the county in a position where the county exec and the staff of the administration, in my humble opinion, just have too much control and authority. There is not that balance, that system of checks and balances that's supposed to be in place if you want a well-functioning government. The legislature is just hamstrung in a lot of ways. Even if they had a 9-0 majority, there would just be things they could not do because the charter just vests too many resources and too much authority on the administration side and doesn't balance things out between the administration and the legislature. So one of the things that we discovered in kind of researching and looking at things was that the charter is there's supposed to be a comprehensive charter review. Stakeholders, county stakeholders are supposed to be appointed. There's supposed to be a formal review. And then charter changes have to be approved by a vote. And that charter review literally, I don't think there's ever been a comprehensive charter review. There were some charter revisions made 2018 or so back in there, where they changed the sheriff to be elected rather than appointed. There were a few of them, and that came about not in a comprehensive charter review process like it's supposed to, but because a legislator at the time felt really strongly that there need to be some changes, and he managed to get it put on the ballot. Hey, hey, thank you. We have a charter review as a committee, but with the recall section, we pretty quickly decided that asking the legislature to consider doing anything formal in terms of a charter review with the recall election going on was probably a waste of breath and time. So for now, we're sitting tight on that recommendation for the county to undertake a comprehensive charter review until the recall election is finished. What I will say has been interesting about the whole recall election happening, and if you follow the news, the charter says you have to collect a certain number of percentage of signatures of those who voted in the last election to trigger the recall. And then the recall was supposed to be held within 60 days. Well, in 1970, whatever, when the charter was passed, 60 days might have made sense as a lead time to hold an election. You know, since that time, federal law has changed. You have to have at least 6 weeks of early absentee voting. You have to send military overseas ballots out 45 days before an election is held. They have to reach those people by 45 days before an election for absentee voting. So it was just a classic example of, well, okay, there's another part of the charter that needs to be changed. You can't hold an election in 60 days after you trigger a recall. That's just not even going to happen. So there had to be litigation there, and a Jackson County judge had to weigh in. And that's how we ended up with the election on September 30th, which was a compromise between, didn't meet the 60-day timeline, but it also wasn't delayed until November, the regular November election. So just another example of things in the charter that just need to be updated and reviewed, the whole thing. Kind of last point I'll make is there is still litigation going on. In fact, there's 3 active cases related to Jackson County. The county executive has questioned the legitimacy of the recall signatures, not based on the signatures themselves, but based on the residence of the signature collectors. And there's disagreement about what requirements apply to those signature collectors, since this is a county recall, not a state petition initiative under the state's petition initiative. Anyway, so even though the recall election is set for September 30th and early voting's already start absentee, and then no excuse early voting will start next Tuesday, there's still outstanding legal questions about the signatures for the recall, and they're still filing motions on that. They haven't scheduled, it's an expedited motion filing, so I don't know if that judge will issue an order again before the recall on the 30th or not. And then there's 2 other active hearings still going on, one related to the assessment with the State Tax Commission, and another is the state auditor suing Tyler Technologies, which was the mass appraisal group that the county used. So I'm still getting notices pretty much daily on one of those 3 cases. It's still moving forward. So again, lots of things still happening. So we're just kind of on hold to wait till after the recall election and potentially final resolution of that before we move forward on this request for and a kind of a comprehensive, systematic charter review.
Thank you for the update, Diane. I appreciate that. And I did not know you were on the Missouri Plan committee. So that's great. Thank you for your service on multiple fronts.
Absolutely. It's a really interesting group in a whole lot of ways.
Yeah, I bet. Mary Ann, do you have a question?
Well, first, I just wanted to say that that was a brilliant, if unprepared, sort of recitation of what we've been doing. So, but just as a matter of general information, so okay, so Frank White is retired. I mean, if he loses the election, he will no longer. Immediately he steps down. Is that not correct?
Correct.
Then what does the charter say about how the replacement is determined?
The legislature has the authority to appoint someone on a temporary basis until the next regularly scheduled election can be held. And I'm not sure if that would defer to November of 2026 or if it would be April of 2026. So it would be one of those two where there would actually be an election.
So then would Ron McGee appoint someone to be the executive?
Yes, the legislature would appoint, and in fact, that's how Frank got into the job in the first place.
Right.
Yeah, he was on the legislature at the time Mike Sanders left.
Right.
And,
Under a cloud. But yeah. Okay, then the thing I was kind of curious about is would the committee that has been working on this then put forward a motion or an effort to revise the chamber, or would you wait until the final the election was over before you would do that?
Good question, and I think that's probably a political judgment. I'm almost thinking it would not hurt there literally because of all of this hoopla about the 60 days. There was actually out loud conversation among the legislators about, okay, the charter's kind of messed up, folks. The charter's backed us into a corner here with this 60-day thing. And they sort of realized, okay, this is, I mean, literally by the time the signatures are certified, they get into a meeting, they try to do something, they were already not going to meet the 60-day timeline. So there was, on the record discussion of, and this was coming from the chair and from Representative Lauer, who is one of the minority there's a split on there, about a 5-4, except there's one vote that kind of goes back and forth. But anyway, basically both sides of the two groups were saying the charter's got problems. So I'm kind of hopeful that when we do make this recommendation, it's not going to be a surprise nor unwanted, so I'm kind of hopeful. Now, it just appears as if it takes the administration a long time, and unfortunately, the charter says the county executive will appoint the stakeholder group that's going to do the charter review. That seems to be a major problem right now. The county passed the new senior tax levy. To implement that, they need to appoint a senior tax something they call commission board. I don't know how they're describing it, but it's made up of one appointee from each of the legislative districts to
put together the application process and to do the review of the applications for spending that money. Yeah, that's every legislative meeting, someone asks, how are those appointments coming, administration? And it's always kind of so there just seems to be, that will be, I think, a challenge, depending on who's the county executive at the time. And, I don't know what the holdup is on those appointments. So many of the planning and zoning, except they call it the Plan Commission, had been without enough members for a quorum for months and months. It just seems to be a real problem to get all these boards and commissions and things that are critical up and functioning well. So that could be an issue, again, depending on what happens with the recall. If Frank is recalled, who else comes into the job, and what they do immediately in terms of addressing some of those issues.
Yeah.
That's great. Thank you.
I just wanted to let you know we have a couple of questions in the chat. I know we need to move on, but one of them is, so the temporary appointee picked from the legislature or from anywhere?
Anywhere.
Okay.
They can, yeah. It's the legislature's call and vote, but they do not have to be a sitting legislator at all, no.
Okay.
No.
And then we have
and yes, I'm pretty sure, I would have to go check, but I'm pretty sure it does have to be same political party, I think. And I would say that is going to happen anyway, because the legislature is a majority Democrat. So I would find it stunning if they didn't do that anyway. But I think that is a requirement in the charter, yes.
Okay, perfect. Well, thank you so much for the update, Diane, and thank you for all your volunteering and commitment to monitoring what's going on in the Jackson County Legislature. I appreciate it.
I appreciate it, and I kind of enjoy it. So.
Oh, good, good. Well, thank you so much. We appreciate it. All right. And Joyce, I know next up we have the video from Emily. Is it Regier?
I think it's Regier, yeah.
Yeah, Regier. And Emily is the state convention keynote speaker. And so, Joyce, I will let you cue that up.
Okay, and I want folks to know that the state was good enough to give this to us, but when they recorded, they weren't planning on sharing, so it's not as polished as the first video was. Can everybody see 67th State Convention?
Yes.
Okay, so I'm gonna let this play for a few seconds after the sound starts so everybody can level their sound. And then I'm going to start it over so that nobody misses anything. And there's no sound at the moment.
We're really pleased to have as our keynote speaker Professor Emily Regier. She's an assistant professor of political science at Mizzou, where she holds a joint appointment in the Truman School of Government and Public Affairs and in the Kinder Institute on Constitutional Democracy. She received her PhD in political science from the University of Pennsylvania.
Okay, I'm going to start it over and hopefully everybody will be able to hear well.
And her JD from Harvard. We're really pleased to have as our keynote speaker Professor Emily Regier. She's an assistant professor of political science at Mizzou, where she holds a joint appointment in the Truman School of Government and Public Affairs and in the Kinder Institute on Constitutional Democracy. She received her PhD in political science from the University of Pennsylvania and her JD from Harvard Law School. Before earning her PhD, she clerked for the Honorable Alan B. Johnson of the District of Wyoming and then practiced law in a large firm in California for several years. Dr. Regier's research connects prominent models of judicial decision-making to different conceptions of democracy. At Mizzou, she teaches courses on constitutional law, American constitutional development, and legal theory. And in these times, we thought this was a very good topic to bring to your attention. So thank you so much.
All right, thank you for that introduction, Marilyn. I'm really honored to be here, particularly honored to be addressing such an engaged and public-interested group with such a distinguished history. I thought I would start by offering a little historical background on the courts and judicial power before trying to apply that to our current political moment. Right, so I'm going to offer a little historical background on the courts and judicial power and then try to apply that to our current constitutional moment. I wanted to begin by talking about the summer of 1987, which was really a monumental time for American constitutional development. It was the 200-year anniversary of the drafting, the writing of the U.S. Constitution, written by delegates in Philadelphia, Pennsylvania, in the hot summer of 1787. The summer of 1987 also gave us the nomination and the bruising confirmation battle of Robert Bork to the Supreme Court, would-be Supreme Court Justice Robert Bork. So on July 1, 1987, then President Ronald Reagan nominated then D.C. Circuit Judge Robert Bork to serve as Associate Supreme Court Justice, to fill the shoes of the retiring moderate Justice Lewis Powell. That same day, Senator Edward Kennedy of Massachusetts took the microphone on the Senate floor in order to describe what he called Robert Bork's America, a place in which women would be forced into back alley abortions, African Americans would be seated at segregated lunch counters, and rogue police could break down citizens' doors in midnight raids without repercussion. So Kennedy's rhetoric was inflated, but the gist of his allegations had merit. As an ardent originalist, Bork was committed to interpreting the U.S. Constitution's guarantees in keeping with its framers' specific original intent. So in Roe versus Wade, for instance, in 1973, the Supreme Court found a right to abortion. And they found that right in the 14th Amendment's guarantee of liberty. No state shall deny anyone liberty without due process of law. But the framers of the 14th Amendment probably didn't have the specific liberty to get an abortion in mind when they passed that amendment. That's for the simple reason that when that amendment was drafted in 1866, ratified in 1868, and for decades thereafter, the majority of states criminalized abortion. And many continued to do so until Roe versus Wade was decided in 1973. So it's hard to say that there was a specific original intent to protect the right to abortion. It's also hard to say that the framers of that amendment meant to stamp out racial segregation and racial inequality in its entirety. The 14th Amendment contains a sweeping equal protection guarantee. No state shall deprive anyone of equal protection of the laws. But when the 14th Amendment was passed, and for decades thereafter, segregated schools were commonplace. In fact, they were seen as so commonplace that there were not major legal challenges to segregated schools until the 20th century. Racial discrimination by private businesses was also rampant. That was challenged in the late 19th century, and in fact, Congress passed important legislation banning it. But the Supreme Court quickly struck down that legislation. The Supreme Court reasoned that the 14th Amendment says no state shall deprive anyone of equal protection of the laws. We're talking about private businesses here, not state actors. So that's just fine. The Supreme Court struck down then important pieces of Reconstruction. All right, so Senator Edward Kennedy also suggested Robert Bork's America was a place in which police could break down citizens' doors in midnight raids without repercussion, likely referring to his hardline originalist view that The Constitution's Bill of Rights, including the Fourth Amendment's protections against unreasonable search and seizure, apply against the federal government, not against state governments. To be fair, it does seem that the Constitution, including the Bill of Rights, was written to define and then limit the powers of the federal government, not to limit the powers of the state governments. Those were already in place. So it wasn't until Mapp versus Ohio in 1961, actually, that the Supreme Court found that the Fourth Amendment, its protections against unreasonable search and seizure, and the exclusionary rule, making sure that unreasonably searched and seized evidence should stay out of trial, it wasn't until 1961 that the Supreme Court applied that against states, against state police officers, and in state courts. So Kennedy had a point. Robert Bork's legal vision did not include many of the court's landmark rulings, expanding civil rights and civil liberties, as well as criminal suspects' rights and the right to privacy, which ultimately came to encompass the right to abortion. But actually, Robert Bork would not have even recognized the right to privacy to cover the right to contraception that the court recognized in 1965. So most Americans, through their elected representatives in the Senate, made clear that they did not endorse Robert Bork's legal vision. He lost. He was resoundingly defeated in the Senate. His confirmation lost by a vote of 58 to 42. It was the widest margin a Supreme Court loss in American history. Bork's rejoinder in 1990 was the New York Times bestseller, The Tempting of America, a book in which he defended his constitutional vision against activist judges, particularly those on the Warren Court, whom he charged with rewriting the Constitution in keeping with their own liberal values. Bork called this constitutional revisionism when 9 elite unelected lawyers, the Supreme Court justices, imposed their own moral and political views, not traceable to the framers' original intent on American democracy. So Bork's attack came from the right. He was part of the resurgent conservative movement in the 1970s and the 1980s. He was President Nixon's Solicitor General and briefly his Attorney General. He was then nominated to the DC Circuit by President Ronald Reagan, and we know nominated to the Supreme Court also by Reagan. Like Nixon and Reagan, as I said, Bork was critical of the Warren Court and previous courts' expansions of civil rights and civil liberties. He thought liberal justices were foisting their values on the American people. But ironically then, the Rehnquist Court, the conservatizing court that Bork would have joined had his nomination gone through, led by the staunch conservative, Chief Justice William Rehnquist, another Reagan appointee, that court turned out to be even more activist. So by the numbers, the Rehnquist Court in the 1990s and the early 2000s struck down not only more federal laws than the Warren Court, but more federal laws than any tribunal in American history. It also rivaled the Warren Court in terms of striking down state laws. And these are laws in both domains in important areas, like affirmative action, environmental protection, campaign finance reform, and redistricting. So just at the federal level, the Rehnquist Court struck down really important pieces of really important legislation like the Violence Against Women Act, the Americans with Disabilities Act, and the Religious Freedom Restoration Act. On the Roberts Court, we've seen this trend continue. Citizens United versus Federal Election Commission from 2010. You're probably well aware that this court in this case struck down important bipartisan campaign finance reform legislation. In Shelby County versus Holder in 2013, the court struck down long-standing voting rights protections under the Voting Rights Act of 1965. In a series of cases from about 2008 to the 2020s, the court struck down a variety of state and local gun safety laws based on a previously unrecognized individual right to bear arms. The past couple of years, we've seen the court strike down a lot of Biden administration efforts to regulate in the interest of the environment and students. For instance, the court struck down regulation efforts by the EPA of carbon emissions and wetlands, efforts by the Department of Education to forgive student loans, and not to mention the Roberts Court has invalidated race-based affirmative action. So before we go any further, I thought it would be only fair to update Bork's title. to the tempting of America, right and left. Because judicial activism has really been a bipartisan affair. Both the right and the left have been tempted to rely on the judiciary to achieve policy gains that they couldn't or
Can you guys hear me?
Yes, I can hear you, Joyce.
Okay. I wasn't sure if I had been booted offline.
left have been tempted to rely on the judiciary to achieve policy gains that they couldn't or
There may be a buffering.
Maybe, but that's quite a lot of buffering.
Yeah. Yeah.
And only 24 more minutes to go. I'm going to try and see if we can do this faster.
Oh, gotcha.
And nope, guess that's not what I wanted.
I wonder, Joyce, is if there's a way we could follow up our meeting with like a link to the video?
That's what I was just about to suggest, that we go
Yeah.
ahead and just post that maybe on the website and people could
That sounds great. I think
their
that's a yeah, no, that's a great solution, I think. And I know that our next item is not in their wildest dreams, peace, love, vote trivia prep. And this probably works out because we were running a little behind, so we're almost back on track.
And so this is the same exact video that we've already watched.
Okay.
But for those wanting to take notes for the trivia contest, the idea was to go ahead and let them watch it again for note taking.
Oh, I gotcha. Is that a
So
video that we could watch in the as a link too?
I am not allowed to do that yet
Okay.
because the people who own it are still showing it around.
I
Which is
understand.
why I'm gonna offer the second, but what I thought, if it's all right with you, because maybe some people don't want to watch it again, is maybe we call for any committee chairs who have anything to say at this point, and then I'll put it on and people can stay or not.
Okay, that sounds great. I think that's a great way to finish up. So if you would like to stay and watch the Not in Our Wildest Dreams again, about the Missouri Supreme Court and the great aspect we have of more women than men serving on the court and the history of women on the Supreme Court, then please stick around. And we will move the last item on the agenda up, which is if there are any committee chairs that have a call to action. I will just mention a couple call to actions is that we the Observer Corps, which Diane represented today, and it is a great group of people who are very knowledgeable in observing public meetings. They are still seeking a chair for that committee, and also we could use a chair for Get Out the Vote. We recently have had just a chair step down, and so we have a open seat to chair Get Out the Vote, which is engaging voters. Are there any other committee chair items that anyone would like to offer?
Kelly Edmonston.
Kelly Edmondson, Chair of Voter Services, and I would just encourage you to go to the volunteer tab after you log in so that you can see everything. And there's a lot of opportunities to volunteer for voter registration coming up in September and October. And they're not, and the requests come in not in calendar order. So I might get a request for something that is earlier than something that's already posted. So the dates are all over the place. So you have lots of options and scroll through all of them. In fact, the last time I looked, it was going to a page 2. So just make sure you see everything and check all the dates, and anything that you can volunteer for would be a big help because people want us, and I want to do the best we can to respond to the request for us to be there for them.
Great, thank you. And thank you, Kelly, for all your work helping to chair and organize all the voter registration events. We really appreciate that. Is there any other items that need to be mentioned during this time? All right, not seeing any. I encourage you to stay if you want to stay and take notes on the video again. And we will have a recording available as well. But I will let Joyce share the video again.
Thank you. Oops.